yesterday we had quite a Supreme Court case that went on, and it is always fascinating when you get a 9-0 court decision. Now, there were actually 2 cases before the court dealing with the Electoral College and this notion of faithless electors. The case that is most noteworthy, I suppose, is Chiafalo v. Washington, and there's a related case of Colorado Department of State v. Baca. And the important thing to note about these cases is that they were separated, but their decisions are basically the same, as I understand it, where the Supreme Court ruled that you cannot have a faithless elector. If you, as an individual, decide to vote against the law of your state for some other candidate that did not win the popular vote of your state, like Washington and Colorado, then you can be penalized by the state for doing so, as it happened in both of these instances. The Supreme Court unanimously ruled in favor of the idea that these states do have such authority. And I wanted to talk about it, dive into this landmark decision with Professor of Law at the Sturm College of Law at the University of Denver. Professor Robert Hardaway is joining us now. He was actually involved in putting forward what's called an amicus brief, or a friend of the court brief in these cases, and that had actually been cited during oral arguments. Professor Hardaway, can you hear me okay?
Yes. Hello. Would you like a little brief background
yes,
about
please.
The Baca case that was decided yesterday?
Yes. Well, welcome to the program, and please do go ahead and set up for us, if you could, in the background, both Chiafalo v. Washington and Colorado Department of State v. Baca, because they both go together in a sense.
Yes, just a brief background. Approximately 32 states, including Colorado, have laws regulating their electors, and indicating that the electors are required to reflect the will of the people in that state. Now, the Constitution, under Article 2, does not say anything about whether electors have free will or whether they. The only thing the Article 2 says is that the legislatures of each state can determine and regulate electors. And it was this basic constitutional provision that the Supreme Court relied upon in saying that states have the power under Article 2 to determine how electors are to be regulated. And that's why they upheld Colorado's law, which regulated electors and provided the requirements for the office of elector. The main requirement is that they vote for, in the Electoral College, the person whom they promised under oath to vote for. And that was the basic principle that the Supreme Court relied upon in their 9-0 opinion, saying that states had the power to provide such laws. Now, other states do not have such laws, and in those states, electors would still be free to vote for anyone they want to. But in the 32 states that, like Colorado, have a law requiring electors to vote for the person to whom they're pledged to vote for, those laws have now been upheld. And this is, I think, a very good result, because we saw in the last election that there was a great deal of threats and intimidation against electors, trying to get them to violate their pledges. And that would mean that we really have two-stage election, one in November and then a second one in December, where all bets are off. And if people are threatened or their fines are offered to be paid, an election could be changed simply on the whim of an individual elector. And back in the year 2000, the election was won by exactly 2 electoral votes. All you'd have to do is change the votes of 2 electors by offering to pay their fines, as was done in the 2016 election, and you could change the entire outcome. So I think this is a very positive result, and that's why I think it was 9-0 in favor of the ruling of the court.
Professor Robert Hardaway, again, of the School of Law at the University of Denver. Good to have you once again on the program. I want to ask you, please, about the notion of the national popular vote. We were talking about this in the previous segment. Please speak to this issue of a stalking horse of sorts that has been claimed, that this is a stalking horse for the National Popular Vote Compact to try and bring that about.
Yes, well, the NPVIC people don't make any bones about it. They say, we really just want to abolish the Electoral College. They have some threshold problems, though. The whole idea of the NPVIC is that some states would form a kind of a cabal, and they would agree to ignore the will of the people in their state and instead cast their electoral votes. The state of Colorado, for example, would cast their votes in accordance with the popular vote in the rest of the states. The problem with that is there is no popular vote. It's based on an illusion that when voters go into the voting booth, they are voting for a presidential candidate. Of course, they are not voting for a presidential candidate. They're voting for an elector. And if that elector then goes on and votes for someone other than the person they're pledged to, how would you count the popular votes, for example, for Hillary, if the voters in Colorado voted for a slate of Democratic electors who had pledged to vote for Hillary, but then they vote for the Republican instead, which is exactly what happened in 2016? There's no way to count popular votes because there are no popular votes for candidates. There are only popular votes for electors. This is the way it works in Great Britain and all the great parliamentary democracies. You vote for in England, they don't call it an electoral college, they call it a parliament. You vote for a member of parliament, and then that member of parliament then goes to the parliament and casts the vote for the leader. But this scheme, this is about the 700th scheme in the last 200 years that has been proposed. But every time this scheme similar schemes have been proposed, they always get shot down by what John F. Kennedy said when he resisted attempts to mess with the Electoral College back in 1956. And what he said at that time was, and he convinced the people not to mess with it. He convinced his fellow senators. He said popular vote election would greatly increase the likelihood of a minority president, that is, a president who received a minority of votes. It would break down the federal system under which the states enter the Union, which provides a system of checks and balances that ensure that no area or group shall obtain too much power. Now, the reason the drafters of the Constitution provided for a separate electoral college was because they wanted to adopt certain elements of the British parliamentary system, which is that you vote for members of parliament, we call them electors, and that they vote for the leader. But they didn't want the same body, the Congress, to be the same body, the elected president, because they wanted a check and balance. They didn't want a president to be beholden to the legislature. And that's why they provided for a separate electoral college. It's really sort of a different branch of Congress, right, but it only has one duty, the duty to elect a president.
Now, how do you think this decision of the Supreme Court in both the cases of Colorado Department of State v. Baca and Chiafalo v. Washington could impact the national popular vote? Could they?
I think it could. I mean, for one thing, it highlights that there is no such thing as a popular vote. For example, how would Colorado decide how to count popular votes for Hillary when the Hillary elector decided to vote for the Republican? Do they count that as popular votes for Hillary, or do they count that as popular votes for Trump or another Republican? There's just no way to calculate it, and the media fosters this illusion. At the bottom of the screen, when you look on election night, it says the popular votes for Trump or Hillary are as follows. Those are not popular votes at all. And in some states, for example, in Alabama, they have been known to present voters with a slate of unpledged electors who have not pledged to vote for any candidate. Now, if the Alabama voters vote for, say, the Democratic slate of unpledged electors, how do you calculate the the number of popular votes to be allocated to a particular presidential candidate. Simply can't be done. And when you present this issue to the MPVIC supporters, they say, well, I don't know how that would be resolved. I guess you just have to disenfranchise all the people who voted for electors that didn't vote for the person that they're pledged to. So disenfranchisement is of hundreds of thousands of voters. And the Baca attempted to basically disenfranchise 138,000 Colorado voters by saying, even though I told my voters that I promised to vote for Hillary, I'm going to vote for a Republican instead. Now, how do you count popular votes in that situation? You can't.
Sure.
So it's a non-starter from the beginning. Of course, there's all kinds of constitutional issues involved with that, but that's just a threshold issue. The MPVI says we'll count as popular votes that are associated with the vote of an elector. But do you count the popular votes for an elector who had pledged to vote for Hillary? Do you count that as popular votes for Hillary, or do you count it as popular votes for the Republican? There's no way to do it. And the newspapers are the ones that count up these popular votes. And delegating to the newspapers, such as Fox News or whatever, the duty of trying to figure that one out is really beyond the pale.
Again, Professor Robert Hardaway, our guest from the University of Denver. Sorry to jump in here, but I do want to go back to some of the specifics of the Supreme Court decision in Chiafalo v. Washington and Colorado Department of State v. Baca, Professor, because there's a lot of discussion that has been going on about the idea of Hamilton electors and what this decision is in terms of the impact, not just on national popular vote, but in general, the idea that states can penalize those who are electors, made the pledge, and then violated that pledge to vote the way that they were supposed to. So I want to pick one here. You can't see this, but I want to read a little bit of Justice Kagan in her decision and then get your reaction. Justice Kagan, writing in Chiafalo, said this, quote, "The elector's constitutional claim has neither text nor history on its side. Article 2 and the 12th Amendment give states broad power over electors and give electors themselves no rights. Early in our history, states decided to tie electors to the presidential choices of others, whether legislatures or citizens. Except that legislatures no longer play a role, that practice has continued for more than 200 years. Among the devices states have long used to achieve their objective are pledge laws designed to impress on electors their role as agents of others. A state follows in the same tradition if, like Washington, it chooses to sanction an elector for breaching his promise. Then, too, the state instructs its electors that they have no ground for reversing the vote of millions of its citizens. That direction accords with the Constitution as well as with the trust of a nation that here we, the people, rule." Professor Hardaway, what did you make of the Supreme Court's opinion 9-0?
Yes. Well, the reason it was a 9-0 opinion was because because the Supreme Court said it was preposterous to say that states don't have the power under Article 2 and the 10th Amendment, according to Thomas. Either one of those don't have the power to regulate how electors are going to be qualified to vote. And I think they were offended by the whole notion that a voter in Colorado could, in good faith, vote for a Hillary elector, and then find out that the Hillary elector is not going to vote for Hillary in the Electoral College. And that effectively, since Colorado has 9 electoral votes, and since this one person, his Hillary elector, decided to violate his oath, that would in effect have disenfranchised 138,000 people who went into the voting booth thinking, "Oh, I'm voting for Hillary." No, they're not. They're voting for a guy named Mr. Baca, who said, "I'm not going to vote for Hillary." So that was the problem that the Supreme Court addressed and said that kind of outrage could never be permitted to continue.
Yeah, in essence, what we are voting for at the ballot box is for electors who will vote for our chosen presidential candidate, whoever ends up winning the popular vote in the state. That is to say, the most number of votes in the state of Colorado or the state of Washington or wherever else the electors who are selected to then go to the Electoral College are those who are pledged to that particular individual. Now, what I also would like you to clarify, Professor Hardaway, is why we have two cases here. We've got Chiafalo v. Washington and Colorado Department of State v. Baca. Both of them have the same sort of conclusion, but technically they're two separate cases. Can you explain that?
Yes, we just have to be careful when we use the term popular vote, because the popular vote you're referring to is not a popular vote for a presidential candidate.
Right.
It's a popular vote in Colorado for a slate of electors
pledged to
who have promised that if you vote for them, they will vote for the candidate.
Right.
So just as long as we're careful when we use the word popular vote, we're not talking about popular votes for candidates. We're talking about popular votes for electors. And when many people have forgotten what they learned in sixth grade civics class. They think that when they go into the voting booth, they're voting for Hillary or they're voting for Trump. No, they are not voting for them. They're voting for a fellow named, among non-electors, they're voting for a guy named Baca who says, if you will elect me, I will promise to vote for Hillary. And then when they violate their pledge, they've basically disenfranchised all the people who went into the voting booth thinking that they were voting for Hillary Clinton, and they were not.
But why are there two cases? Why Chiafalo v. Washington and Colorado Department of State v. Baca? How did that work?
Well, yes. In Washington, they had a law that said that electors are required to vote for the person they're pledged to vote for. But they didn't provide for replacing the elector if they violated their pledge. They just said you get a $1,000 fine. And that's why in the 2016 election, a lot of people were trying to harass electors, saying, well, we'll pay your fine for you. Go ahead and change your vote. Change the whole election. We'll pay your fine. But the question in the Washington case was, can the state of Washington, do they have the power to fine somebody to enforce their law that says that electors have to vote for the person that they're pledged to vote for? But in Colorado, it was different. They didn't mess with fines or prison terms. They just said, you haven't qualified as an elector, because one of the requirements that we've established for an elector is to vote for the person that you promised to vote for. So they said, now that you have not qualified, we get to replace you. Just like on a jury, if a 15-year-old gets on a jury and is not qualified to be a juror, that juror is replaced. That's exactly what the state of Colorado did, according to state law, which says if you don't meet the requirements, you will be replaced. And so that's what the Colorado did. They replaced the elector who had not qualified, and they simply replaced it. But the Supreme Court said that either one of those enforcement provisions is constitutional. And I understand also that now Washington realizes a $1,000 fine is not a very effective enforcement mechanism. So I understand that they are now changing to the Colorado version of the statute, which is that we're not going to send you to jail, we're not going to fine you, but we're going to replace you. So that's the difference in the two cases.
And finally, Professor Hardaway, can you tell us about your amicus brief? I know that was referenced during oral arguments and so forth. Can you talk a little bit about that?
Yes, I filed an amicus brief. I'm a friend. It means friend of the court, because I was very concerned because there was a 2-to-1 decision in the the 10th Circuit Court of Appeals that said that the states were powerless to require electors to reflect the will of the people in their respective states. And I've been studying the Electoral College for over 40 years, as a matter of fact. I first got interested when I was at the age of 16. And I was in a government class, and we used to debate this whole question of the Electoral College. And the person who opposed me at that time was a fellow named Al Gore. He was my classmate at the time. And so ever since that time, I have been most interested. I've written a number of books, because a lot of people don't understand the history of the Electoral College. They don't understand that it was the compromise that created the United States of America. We wouldn't have the United States of America because at the Constitutional Convention, the big state brutes said we should just have a Congress that is based on population. The small states said no. Every state should have a say, and we should have equal suffrage. And so at the last minute, it was Benjamin Franklin who probably was the one who proposed a compromise. Well, let's do both. That's how we will create a federal republic. So the country can't be ruled by little enclaves and on the coast, for example, with ignoring the interests of the hinterland. It must be broad support across the entire country, and that has served us very well. Also, most of this is political theater, because most people have also forgotten what they learned in sixth grade civics was about the last sentence of Article 5 of the Constitution, which says you can't take away equal suffrage in the Senate. That is, every state gets equal number of senators in the Senate. You can't do it unless every state agree. It's the only provision in the entire Constitution which cannot be amended by constitutional amendment. It requires unanimous consent of the states. And of course, every state's weight in the Electoral College is based on that equal suffrage in the Senate, which cannot be abolished unless every state agrees. And that will never happen. That's why I call most of this discussion totally political theater, because it simply will not happen.
It's so fascinating. And the most intriguing tidbit that you said, I have to say, is that for like his whole life, Al Gore has had issues with the Electoral College.
Well, yes. It's interesting, too. Another tidbit is that back in 1960, it was the Republicans who thought that the Electoral College favored Democrats, and they had a good point, because in fact, in the 1960 election, according to the New York Times and according to the Congressional Quarterly, Kennedy won the electoral vote, but did not win the popular vote. And so the Republicans were convinced that the Electoral College was some kind of anachronistic institution that was prejudiced against Republicans. But demographics change, and some people now claim that the Electoral College favors Republicans. It changes according to the demographics. When I went in 2003, when they first tried to put through this NPVIC scheme, I went down there and I said to the Senate committee, I said, if you'll give me 10 minutes, I can explain to you why this is totally ineffective. It can never be implemented. And they were had a preliminary vote of 10-1 in favor of the NPVIC. After they listened to me for 10 minutes, they changed their vote to 10-1 against it. They said, of course it can't work. You can't even have a recount. How can you have a recount when some states would recount and others wouldn't, according to their state laws? You can't have a recount when only some states. So they basically said it was ridiculous. But then last year they tried again, like a bad penny. They came back through the back door. But this time there were over 200 people that were there trying to give their opinions as to why they didn't like the Electoral College. And virtually all of them had only one argument. Their argument was, well, there must be something wrong with the Electoral College. It didn't elect my favorite candidate. And that was the extent of their argument.
Sure.
I was given only 1 minute so I was not able to reverse the Senate vote. So I'm afraid that Colorado has now become part of that scheme, the cabal.
Fortunately for our shared state of Colorado, Professor, we do have the opportunity in November to vote down the National Popular Vote Compact. We'll see what happens there. But Professor Robert Hardaway of the College of Law at the University of Denver, who again filed an amicus brief in the Colorado case, Colorado Department of State v. Baca. So great to have your insights today. Thank you so much for taking the time to join us on Jimmy at the Crossroads.
Thank you. Thank you.
And have a great day.
Thank you.
Be well. Once again, Professor Robert Hardaway of the University of Denver joining us here on Jimmy at the Crossroads. Thanks for watching this clip from Jimmy at the Crossroads. You do not want to miss a minute of engaging, intelligent talk. Subscribe today to the Jimmy at the Crossroads YouTube channel, and you'll be sure to catch our live broadcast. I appreciate your support.
I got Jimmy at the Crossroads, making sense out of no sense. Yeah.